Our morning panel will consider national and state powers in the realm of immigration. And I'll do both introductions because then they will just speak one after another. And at the end of their talks, it will be an opportunity for audience questions before lunch. So that's the plan ahead. Lucas Guttentag is a professor at Stanford Law School, also at Yale Law School. He is the founder and has a distinguished career as National Director of the ACLU's Immigrant Rights Project from 1985 to 2011. He served in the Department of Homeland Security as Senior Counselor to Secretary Jay Johnson, and is really one of the great leading figures in the field of immigration law. As I was canvassing, the first name everybody said was Get Lucas. And luckily it turned out to be easy because he's totally wonderfully cooperative to get Lucas. And the ability to get Lucas, if you will, really made it possible to build the rest of this program. So without further ado, Lucas Guttentag.
Thank you very much. Well, right into the mic, you said, right? Is that okay? All right, thank you very much. It's really a pleasure to be here. And thank you, John. Thank you, Susan. Thank you to the Robert Jackson Center for the opportunity to speak. It's an incredible honor and pleasure for me to participate in this program because the opinions, the language, the career of Robert Jackson have featured prominently in my teaching for the last 30 years. His dissent in the Mazzei case, to which I want to return, is remarkable and continues to be of critical importance today, because the principle that the court adopted in that case, to which he dissented, has never been abandoned. And what he has to say remains an essential question that the court will have to, I believe, grapple with soon. But before teaching full-time, as John mentioned, I served as director of the ACLU Immigrants' Rights Project for a long time, litigating cases on behalf of immigrants and refugees, and to try to enforce, expand, advance the constitutional rights of non-citizens. Those rights have grown significantly over the last 20 years, but they remain in many important respects impoverished compared to what we think of as established constitutional rights. Just as an example, immigrants have no right to appointed counsel in deportation proceedings. If they can't afford a lawyer, they go unrepresented, and the overwhelming majority do not have lawyers when they're subject to deportation proceedings. There's no prohibition on ex post facto laws to make an immigrant deportable based on something that was not illegal when he or she engaged in it. They're subject to long-term detention, months and even years, without any kind of hearing on whether they pose a flight risk or a danger. That issue actually is before the Supreme Court right now, and I was looking this morning to see whether the court was issuing an opinion in that case. They have not yet. They may well do that before the end of the term or have it re-argued next term. Immigrants are subject to summary exclusion if they arrive at the border, notwithstanding the fact that we recognize that it's part of the United States. And even access to federal court review by an immigrant subject to expulsion, even though guaranteed in theory by at least the suspension clause of the Constitution, continues to be contested by the government in many important contexts. So all of these rights continue and need to be developed more fully. But my task today is to take a little bit of a step backwards and to give a thumbnail sketch of some of the legal and historical context in which we're going to discuss the more immediate issues of today in Rick's presentation and in the presentations this afternoon. Of course, controversy over immigration is nothing new. It's as old as the Republic. We all have heard of the famous statement by Benjamin Franklin that the Germans of Pennsylvania would never become citizens, would never learn English, were too insular to become American citizens. And I think that in that respect, it's important to recognize there's always been two strands in our views of immigration. On the one hand, it's absolutely true what the iconic Statue of Liberty represents, open and welcoming towards new immigrants. On the other hand, we've always also had that strand of xenophobia and racism and hostility towards those who are arriving. The first federal immigration laws were not enacted until 1875, and that law prohibited the entry of convicts and prostitutes. But very shortly thereafter, in 1882, I just forgot the critical thing that I always start with, which is, it's a good thing I have the slides, is that I always want to remind myself and everyone, why is it that immigrants should be protected? Why should non-citizens have essential constitutional rights? It's because of the words of the Fifth Amendment and the words of the 14th Amendment that we should always keep in mind. It doesn't say that every citizen is entitled to due process and that every citizen, it says every person is entitled to due process of law. Every person is entitled to equal protection of the law. That's the fundamental guarantee. It's not reserved only to citizens, and there are plenty of places in the Constitution that refer specifically to citizens. The 14th Amendment and the Fifth Amendment do not. They speak in terms of persons. So, returning to the legislation, 1875 had the first federal immigration law, but then shortly thereafter, in 1882, the Chinese Exclusion Act was passed. Literally at the same time that the Statue of Liberty was being built, the Chinese Exclusion Act was enacted. And that was an outgrowth of principally the racism in California towards Chinese, the lynchings, the discrimination, the widespread hostility towards the Chinese in California. But like many things, it permeated Washington as well. And in 1882, Congress passed the Chinese Exclusion Act. And what it did was it prohibited any new Chinese laborers from entering the United States. It deported all those who couldn't prove through the testimony of two white citizens that they were lawfully in the United States. And it prohibited even the return of those who had left with permission and with the promise that they would be allowed to come back. There was nothing subtle about it. The law and the statements in Congress were permeated with racism, and the case ultimately reached the Supreme Court in a case called Chai Chan-ping, or now generally referred to as the Chinese Exclusion case. And the issue the court had to decide was the scope and the source of federal government's power to regulate immigration. Chai Chan-ping had been working and living in the United States. He got a certificate of residency. The certificate of residency allowed him to leave, to go home to see his family, and with that certificate, to return to the United States. He did that. He got the certificate. He left. And between the time that he left and came back, Congress changed the law and said that the certificate is no longer a basis for return. No one can come back who's not already here. That case reached the Supreme Court, and it upheld the power of Congress to enact that legislation. And in words that should be chilling, they weren't then, but they are now, as the court said, if the government of the United States, through its legislative department, considers the presence of foreigners of a different race in this country who will not assimilate to be dangerous to its peace and security, their exclusion is not to be stayed because we're not at war, because we do not have actual hostilities. It was a sweeping affirmation of federal power to exclude, even on the basis of explicitly racial grounds. This was and became the beginning of the so-called plenary power doctrine that gives the federal government virtually unbridled authority to set the substantive category and grounds for who shall be allowed to immigrate and what the grounds of deportation are. It became the foundation of deference by the courts to the political branches. In many respects, of course, the court has moved on. What's remarkable about this case is that it still gets cited today. In the immigration world, we're still mired in this era of Chinese exclusion and the cases that followed. It has never expressly been overturned, and it continues to be cited by the government as the source of its authority. Now, after Chinese exclusion, there were successive other acts that were passed, and this was the era of great migration from the 1890s through the 1920s to the United States, as many of you know. It was also the beginning of, or the time of, a significant shift of immigration from Northern Europe to Eastern and Southern Europe. It was a shift in immigration from principally Protestant immigration, with the exception, of course, of the Irish, who faced enormous hostility when they first came, to Catholic and significantly Jewish immigration of the turn of the century. From lighter-skinned immigrants to darker-skinned immigrants. It was an era when millions upon millions of Italians and Poles especially migrated to the United States. And it generated enormous hostility. The Japanese were not covered by the Chinese Exclusion Act because it was specific to Chinese. The Italians, who were subject to discrimination, the hostility to Catholics, who were characterized as owing their fealty to a foreign religious leader, not to the democracy, and of course, to the hostility against those who were not Christians, Jews, and those who were characterized all collectively as criminal, as lazy, as not potentially good Americans. And just before our conference started, I was handed the original version, or a copy of the original version of that picture that's, whoops, oh no, that's not, where's the, is the pointer?
In the middle.
Oh, thanks, oh, got it. This, which evidently was done, the work was done by an artist at the Chautauqua area. So there was a lot of agitation for greater restriction. And the first thing that Congress did was enact the so-called Asiatic Barred Zone, which swept far beyond China and all through Asia, still not covering Japan, but all of South Asia, and barring all immigration from that entire area. And then that ultimately led to the infamous National Origins Quota Act, with which many of you are probably familiar. This was law enacted by Congress, openly and explicitly racist, anti-Semitic, anti-Catholic, designed to prohibit the immigration that had been coming since the turn of the century. It was originally set at, as you can see here, at a 3% quota of what the population was in 1910, but then changed and finalized to limit immigration from all countries to 2% of the number of people from that country, of that nationality, who had been in the United States as of 1890. So in 1924, the goal was to preserve the ethnic, religious makeup of the United States as it had existed 30 years earlier, 35 years earlier, before the great wave of Eastern and Southern European migration. And it had stark effects. The number of immigrants from Italy had been in the neighborhood of 150 to 250,000 per year before the Quota Act went into effect. Every year, roughly 200,000, on average 200,000, for the preceding almost 20 years. Similarly, with Poles, there were roughly 2 million Poles who had immigrated to the United States during that preceding period. When the quotas went into effect, Italian immigration, for example, was reduced to 6,000 per year from the almost 250,000 in the preceding years. And Polish immigration was cut to 4,000 a year. And that happened across the board with all countries because, again, it was based on a population of the period before the migration had happened. So that was the Quota Act, and that's what governed American immigration for almost 40 years, more than 40 years, excuse me. Now, during this period, though, during the subsequent period, there were also some positive developments. There was lots of litigation brought by individuals in the United States who were subject to removal. A lot were alleged to be communists, anarchists, other subversives, also individuals alleged to be affiliated with organized crime. And there was litigation about the rights that individuals had as part of the deportation process. And over the period between roughly 1903 through the 1950s, the Supreme Court significantly expanded the procedural rights that individuals subject to deportation had. They didn't question the power of Congress to set the categories, but they said that the process had to comply with fundamental principles of due process under the Fifth Amendment. And the court developed in a series of cases this principle that due process had to be rigorous, that great deal was at stake for someone who was in the United States and being expelled, and so therefore the highest level of scrutiny, at least by the standards of those days, should apply to the fairness of the deportation system. So at that point we had essentially the court operating on two tracks with regard to its scrutiny of the immigration system. On the one hand, the categories that Congress set were virtually immune from review. The procedures that individuals were entitled to in the deportation process were supposed to be subject to very high, demanding procedural scrutiny. And then the Mazzei and the Knopf cases happened. And this was during the height of the Cold War, the early 1950s. First, Ellen Knopf, as John was saying, was denied entry as the bride of a United States citizen based on secret evidence that she was not allowed to see. And then Mazzei was denied return after having lived in Buffalo for 25 years, based also on secret evidence that he could not see. Mazzei, as John was saying, was in particularly dire circumstances because Ellen Knopf could have been, had it not been stopped by Justice Jackson, could have been sent back to Germany. Mazzei had no country that would take him back. Nobody recognized him, and as Justice Jackson said, why should we be surprised that a person that we call a Samson who will tear down our temple or gates is one that other countries should be afraid to take? No one would take Mazzei back. He had no country, and he would be stuck in detention at Ellis Island for the indefinite future. The court decided that case, and against the backdrop of expanded procedural due process rights that it had been announcing in other cases, said Mazzei was different, said that because he was at Ellis Island, was at the border returning from abroad rather than inside the United States, that he had no procedural rights at all, that the only process he would get is what the government decided he should get, and nothing more. And that was the principle against which Justice Jackson dissented so strongly. And the dissent, not only the language that you've already heard, but the rest of it is compelling because part of what Justice Jackson does in his dissent is analogize U.S. practices to those of the Nazis that he had cross-examined in Nuremberg and to Soviet law that was the basis for the Cold War. It was a stinging rebuke to what he saw was an abuse of government power. Now, as Jackson scholars know, Justice Jackson had a law clerk during that period who urged him not to dissent and rather to join the majority. That law clerk was William Rehnquist. In a famous memo that became public much later, urges Justice Jackson not to dissent. Of course, he disregarded that. Justice Jackson's dissent has two really important pieces to it, in addition to all of the points that he makes. One is he completely rejects the notion that whether someone's at the border or in the interior should matter for purposes of the fairness of the process and entitlement to procedural due process. But note what he accepts as the governing law of the day, which is that Congress can set the grounds on which a person can be denied entry. Congress has ample power to determine whom we will admit to our shores and by what means we will effectuate its exclusion policy. He's not disagreeing with the power to exclude someone based on their ideology, based on their affiliation, or on other grounds. But he does say there has to be an adequate process to challenge the grounds on which the government says that he fits within a ground of inadmissibility. So that was the governing law, and we were still under the National Origins Quota Act. And then, as part of the great civil rights movement in this country, things began to change. And in particular, in 1965, Congress finally repealed the National Origins Quota Act as part of the same Congress that enacted the great civil rights statutes of the 1960s, the Voting Rights Act, the Employment Anti-Discrimination Act, and so on. In 1965, Congress finally accepted what many had said for decades, that the National Origins Quotas Act, grounded in the acceptance of the discrimination of the Chinese Exclusion Act, had to be repealed. So in 1965, we ended the existing quota system. We apply the same numerical limits to all countries, and the consequence is dramatic. And you can see both the drop-off in the 1920s after the Quota Act was enacted, and then the flat, and then the change that's happened over the course of the last 30-plus years as the 65 Act became fully implemented. And so we've seen a significant increase, especially in Asian and also in Latin American immigration. Now, there is a consequence to the 65 Act as well, and that is that for the first time, limitations were placed on Western Hemisphere immigration. Mexico, for the first time, became subject to numerical limitations as a result of 65 and ultimately the amendments in 1976. So a lot of what we experience with Mexican migration and with undocumented Mexican migration is a result of what happened in 1976 and then the subsequent enforcement at the border, and that broke the cyclical and circular migration that had been happening across our southern border for decades and decades and decades. Both Presidents Ford and President Carter urged that Mexico be treated differently than the rest of the world because of our historic connections and because of the migration patterns, but that has never happened. So what we can see is what's happened with immigration since 1965. We are at an historic high in terms of numbers. We are not, but we are approaching the high in terms of percentage of the U.S. population. The red line is the percentage of the U.S. population that are immigrants. The bars are in absolute numbers. So the numbers back in the turn of the century in the 1800s, of course, were much, much lower, but they represented a much higher percentage than we have today. And this new wave of immigration, along with lots of other circumstances, I think has led to a whole series of very harsh measures. It started in the 1990s with the 1996 Immigration Act that imposed a great deal of mandatory detention, expansion of detention, made minor criminal convictions retroactively grounds of deportation for long-time legal permanent residents, attempted to deny access to the federal courts to immigrants subject to removal. Now, the Supreme Court has rejected some of those most extreme measures, but importantly, to this day, it has not overturned what the court held in Mazzei. It has distinguished it, it has avoided it, it has not overturned it. Nor has it, and so immigrants arriving at our borders today, whether the southern border in Texas, the ports are ports of entry, those individuals are deemed not to have any procedural due process rights under the Constitution. If Congress chooses to provide them a hearing, they will get one, or they should, but it's not guaranteed by the Constitution, and there's nothing to prohibit Congress from taking it away. And now, of course, we face many of the new issues that we're going to talk about today that raise some of these questions in very contemporary times. The travel ban and whether religious discrimination is permissible, the kind of border enforcement and expulsion that's carried on, whether someone can be denied a hearing, and whether Congress can redefine the border so not only is it where a person arrives, but someone who's been here for only a short period of time should be deemed to still be at the border, whether there's prolonged detention without kind of any hearing is permissible, questions about legal representation, whether there's effective access to the courts, the questions of state and local enforcement and resistance that Rick is going to talk about, and importantly, proposals for new barriers to legal immigration. So I'm going to close with just 2 points. First, as the great constitutional international scholar Louis Henkin said, Chinese exclusion, the case that still is on the books and cited, was decided in the shadow of Dred Scott, in the era of Plessy versus Ferguson, before Brown versus Board of Education, before the emergence of individual rights or international human rights. As he says, I cannot believe that the court would hold today that the Constitution permits either exclusion on racial or religious grounds or deportation of persons lawfully admitted who have resided peacefully here. Well, the question of exclusion on religious grounds, I think we'll get some insights into very soon. The second point I want to make in conclusion is that the questions we face today go far beyond what the courts will decide. Just as the 1924 Act was changed not by an action of the court, but because of the political and social movement of the civil rights movement. The questions today are really political questions that we face as citizens and as members of this society. They go to the very soul of our country. And I believe that there are those in the country and in our current administration who want to return us to the era of the 1920s, who want to use immigration to turn back the clock, to use immigration to achieve their vision of a white Christian Northern European nation. I know that sounds harsh, but I think it's what is true. And that's the question that we as citizens ultimately have to confront, is who we are as a nation and what we believe in. How do we continue to preserve the diversity and struggle for the tolerance and the equality that we believe are the essence of America? Immigration has never been an historic artifact that somehow created America and then stopped. It's an ongoing, dynamic process in every generation and in every period. And immigrants change America, and they in turn are changed by America. And the ultimate question to me is that something that we fear or that we celebrate? And I believe it's something we should celebrate. Thank you.